The Pacific Northwest sky was the color of worn slate, pressing down on the chill steel-blue waters of Puget Sound. To the residents of the exclusive Eagles Eyrie gated community on the mainland shore, the view was one of pristine, if moody, beauty. And for years, the small, ruggedly forested island a mile offshore had been a part of that view, a silent, uninhabited parcel of wilderness that added to the area's prestige. That is, until the Cranes arrived. The island, known officially as Nisqually Rock, had been purchased 3 years prior by a reclusive tech billionaire named Silas Thorne. The sale had caused a minor stir in Eagles Eyrie. The HOA board, led by its fiercely territorial president, Gerald Fitzwilliam, had attempted to block it, citing a dubious view corridor clause in the community covenants. Thorne's lawyers, a pitbull firm from Seattle, had dismantled their case in a 12-minute hearing. Thorne took possession and for 2 years nothing happened. The island slept. Then the construction began. Not the discreet shingle-and-stone architecture of Eagles Eyrie, but something starkly, defiantly modern. A low, circular structure of glass and weathered steel emerged from the trees, looking less like a house and more like a terrestrial observatory. A sleek, private dock replaced the rotting old one. Most alarmingly to Gerald Fitzwilliam's sensibilities, a 40-foot-tall, brushed aluminum sculpture was erected on the western promontory. In the right light, it resembled a twisted helix. In the fog, a ghostly monolith. It was, Fitzwilliam spat at the next HOA meeting, an aesthetic atrocity. The complaints began as whispers over gin and tonics, then formalized into letters. The sculpture violated community visual standards. The lights from the glass house at night were a nuisance. The speed of Thorne's watercraft created excessive wake. Each letter was met with a terse, legally precise response from Thorne's attorneys, culminating in a final one. Mr. Thorne's property is not, and has never been, subject to the Eagles Eyrie Homeowners Association covenants. All further communications will be considered harassment and dealt with accordingly. Fitzwilliam, a man whose authority had never been so blatantly flouted, reddened with fury. He embarked on a crusade. He called in favors at the county planning department. He discovered a forgotten century-old ordinance about marine nuisance structures. He found an environmental regulation about nearshore habitat disruption, related to the new dock pilings. He amassed a dossier of what he called blatant violations, each one thin but together he believed formidable. He bypassed Thorne's lawyers and went straight to the county sheriff, an old fishing buddy named Roy Danvers. Over a bourbon, Fitzwilliam painted a picture of an arrogant outsider flouting the law, threatening the ecosystem and destabilizing property values. He presented his dossier. Danvers, skeptical but obligated to investigate, agreed to lead a multi-agency compliance inspection. Just a look-see, Jerry. If he's in violation, we'll issue a notice. What Fitzwilliam didn't say, and what Danvers didn't fully grasp, was that Gerald had also tipped off the local media. He wanted a spectacle, a show of force that would humiliate Thorne and reassert the HOA's dominion over the entire bay. That is how, on a damp Tuesday morning, a flotilla of official vessels surrounded Nisqually Rock. The Sheriff's Patrol boat, 2 Department of Natural Resources skiffs, and a Planning Department launch bobbed in the choppy water. Aboard were deputies, uniformed officials, and a reporter and cameraman from the local news. As they approached the dock, they saw a single figure waiting, a tall, lean man in his 40s, with close-cropped hair and a calm demeanor, dressed in simple, functional clothing. This was Silas Thorne. "Mr. Thorne," Sheriff Danvers called out, stepping onto the dock. "We have warrants here for a compliance inspection of several potential code violations. We'd appreciate your cooperation." Thorne scanned the flotilla, his eyes lingering on the news camera. A faint, unreadable smile touched his lips. "Of course, Sheriff. My home is open. But a word of caution." "What's that?" Danvers asked, chest puffed slightly. "The island is a private domicile, and as such, is equipped with a comprehensive security and monitoring system for my research. Your every action and word will be recorded in multiple spectra. I also must inform you that you are trespassing on a federally recognized, sovereign entity." Danvers chuckled, and a deputy snorted behind him. "Sovereign entity? This is San Juan County, son. Now let's start with this dock permit." "No," Thorne said, his voice still quiet but now carrying a blade-like edge. "You misunderstand. I am not a citizen subject to your county permits on this land. I am the Chief Executive Officer of the Thorne Foundation, a United Nations-recognized non-state sovereign entity, NSSE, with permanent observer status, engaged in climate and oceanic research. This island is its sovereign soil, purchased and recognized under the 1933 Montevideo Convention on the Rights and Duties of States, and registered as an extraterritorial research station under a 1994 UN Covenant on Scientific Sovereignty." A stunned silence fell, broken only by the cry of a gull. The news camera whirred. Fitzwilliam, who had insisted on coming along in the DNR skiff, spluttered, "That's preposterous. This is America." Thorne ignored him, keeping his eyes on Danvers. Sheriff, your warrants issued under county statute have no jurisdiction here. By proceeding, you are violating international law and the diplomatic immunity granted to this foundation's premises. The foundation's legal team has already been alerted and is filing injunctions and diplomatic protests as we speak. However, to avoid an unnecessary international incident, you may proceed with your inspection under explicit duress and protest. Please follow me. He turned and walked up the path. The officials, confused and suddenly less sure, looked at Danvers. The sheriff, a pragmatist, felt a cold knot of dread form in his stomach. The jargon was overwhelming, but Thorne's absolute certainty was palpable. We came all this way, he muttered. Well look, but everyone keep your hands in your pockets. Don't touch anything. The inspection was a farce conducted in a dreamlike state of legal uncertainty. Thorne led them through the stunning, minimalist home, which was less a residence and more a laboratory. Walls displayed real-time global ocean current maps, atmospheric CO2 readings from the South Pole, and complex fluid dynamics models. The nuisance lights were full-spectrum environmental simulators for studying coral polyps. The dock's design, he explained, was a patented erosion prevention system he was beta testing for the Maldives government. Every question was met with an answer that was both simple and utterly alien to their frame of reference. A query about the building permit for the sculpture was answered with, the ELIS column is a calibrated atmospheric sensor array, part of a shared data treaty with the World Meteorological Organization. Its installation was approved under the Vienna Convention on Diplomatic Relations, Article 22, pertaining to mission premises. Fitzwilliam grew more apoplectic with each moment, pointing at a composting toilet unit and yelling about septic violations, only to be told it was a water reclamation prototype funded by the Singaporean government. After 2 hours, the officials had found nothing they could comprehend, let alone cite. They left the island under the silent, recording gaze of dozens of discrete sensors, their authority utterly deflated. The real battle, however, was just beginning. It moved from the damp island air to the sterile, pressurized atmosphere of the United States District Court for the Western District of Washington. The county, egged on by a publicly embarrassed Fitzwilliam and a sheriff now fighting to save face, filed suit against Silas Thorne for flagrant violation of building, environmental, and zoning codes. They expected a battle of attorneys. What they got was a diplomatic thermonuclear war. Thorne's legal team did not merely respond to the lawsuit. They filed a countersuit of breathtaking scope and audacity. The defendant was not Silas Thorne individual, but the Thorne Foundation, a sovereign entity. The charges were violation of sovereign immunity, trespass on diplomatic soil, illegal search and seizure under color of law, and attempted extraterritorial enforcement of municipal statute. Their first move was a motion to dismiss based on the Foreign Sovereign Immunities Act, FSIA. Thorne's lead counsel, a formidable woman named Alara Vance, argued that the foundation, as a UN-recognized NSSE with observer status, was entitled to the same immunities from the jurisdiction of U.S. courts as any foreign state. The county's lawyers scoffed, arguing that NSSE status was an obscure administrative category, not equivalent to statehood. Then Vance entered Exhibit A into the record, a thick dossier of treaties, recognitions, and agreements. There was the foundation's charter, granted by a European micronation. There were letters of recognition from 7 Pacific Island nations, all beneficiaries of the foundation's climate research. There was the UN Observer Certificate. And most damningly for the county, there was a diplomatic note from the U.S. State Department's Office of Foreign Missions, acknowledging the Thorne Foundation's status and registering its headquarters location. The address was a P.O. box in New York, but its primary research territory was listed as Nisqually Rock, San Juan County, WA. The judge, the Honorable Margaret Wynne, a no-nonsense jurist with decades of experience, stared at the document with profound unease. Counsel for the county, she asked slowly, are you telling me that your office conducted an armed inspection of a property that the State Department recognizes as foreign soil? The county attorney stammered. They hadn't checked. It never occurred to them to check. The hearing became a crash course in esoteric international law. Vance called expert witnesses, a former Undersecretary of State for International Organizations who explained the nuanced but very real standing of certain foundational NSSEs, a professor of geopolitical law from Yale who detailed the history of scientific extraterritoriality, and a former ambassador who testified that barging onto such a recognized entity's premises with armed officers was, in diplomatic terms, somewhere between a profound faux pas and an act of aggression. The county's case, built on plumbing permits and setback rules, crumbled into absurdity. Every time they tried to argue a point about shoreline management, Vance would object. Irrelevant. The subject property is not shoreline under the county's definition, as it is not within the county's jurisdictional territory. They tried to argue the foundation was a sham, and she presented 10 years of peer-reviewed, globally impactful climate research published by the foundation, funded by grants from governments and institutions worldwide. Fitzwilliam, called to the stand, was a disaster. Under Vance's surgical cross-examination, his motivation unraveled. She presented the string of HOA complaints, his emails to the media boasting about taking the islander down a peg, and his fishing trips with Sheriff Danvers. She painted a picture not of civic duty, but of a petty tyrant whose wounded pride had escalated into a catastrophic overreach of authority. Isn't it true, Mr. Fitzwilliam, that this was never about dock pilings or light pollution? It was about the fact that Mr. Thorne's island and his success was the one thing in the beautiful bay you couldn't control. He had no answer. The final blow was the security footage. Thorne's legal team submitted edited highlights from the island's surveillance. There was the flotilla looking ominously aggressive. There was Danvers, warrant in hand, the very image of local authority. And there was Thorne, calm and polite, issuing his warning about sovereignty, which was clearly heard on the audio. The footage then followed the officials as they moved through the home, their confused and increasingly sheepish expressions captured in high definition. In one damning clip, a deputy was seen gingerly picking up a strange-looking seashell from a desk, only for a calm automated voice to emanate from a speaker. Please replace the deep-sea lithospheric sample. It is part of an active paleoclimatology study. The deputy jumped as if shocked. In her closing arguments, Hilara Vance didn't just ask for a dismissal. She eviscerated the county's position. This case is not about zoning. It is about the arrogance of the parochial when confronted with the global. My client did not seek conflict. He sought solitude to conduct work that benefits this planet. He was met not with curiosity, but with a show of force orchestrated by a homeowners association bored by its own luxury. The county, rather than doing its due diligence, became the HOA's unwitting muscle. They turned deputies into HOA enforcers, and in doing so violated treaties, ignored federal recognition, and committed acts that, if done to the embassy of any allied nation, would require a formal apology from the president. The only appropriate remedy is not just dismissal, but a ruling that affirms the Foundation's sovereignty and compensates it for this egregious violation. Judge Wynne took a week to deliberate. The ruling, when it came, was a masterpiece of legal clarity and sheer astonishment for the local community. She granted the motion to dismiss the county's case with prejudice, meaning it could never be refiled. She found that the Thorne Foundation did indeed qualify for sovereign immunity under the FSIA, given its unique recognition by the State Department and its UN status. The county's actions were, therefore, ultra vires, beyond their legal power. But she went further. In a scathing rebuke she found for the Thorne Foundation on its countersuit. She issued a declaratory judgment that Nisqually Rock was recognized as the sovereign territory of the Foundation for the purposes of its diplomatic and research missions, and that county laws could not be enforced upon it without express federal consent. She ordered the county to pay the Foundation's legal fees, which ran into the millions. And in a final symbolic twist, she ordered Sheriff Danvers and Gerald Fitzwilliam to jointly pen a formal letter of apology to be delivered to the Foundation and copied to the State Department's Office of Foreign Missions. The news story, which had begun as a snippet of Local Man Fights HOA, exploded into an international curiosity. Thorne, in a rare public statement, struck a magnanimous yet pointed tone. The Foundation's work continues. We bear no ill will to the people of San Juan County. We hope this clarifies the boundaries, both legal and metaphorical, so we can all return our focus to more important matters, like the changing acidity of the very waters that surround us. On the mainland, the fallout was immediate and bitter. Gerald Fitzwilliam was ousted from the HOA board in a landslide vote of no confidence. His name became a local byword for catastrophic pettiness. Property values in Eagles Eyrie didn't plummet because of Thorne's lights, but they did dip slightly from the sheer embarrassment. Sheriff Danvers, nearing retirement, chose to step down early, his reputation forever tarnished by the island fiasco. And on Nisqually Rock, the lights of the glass house still glowed softly in the night, no longer a nuisance but a beacon of untouchable, legally enshrined independence. The twisted aluminum sculpture, the Aeolus column, stood against the sunset, no longer an eyesore but a monument to the fact that sometimes, the most powerful weapon against small-minded authority is not a bigger gun, but a deeper, more profound understanding of the law. The police had surrounded the private island, armed with warrants and indignation. And they had left, surrounded